Hello and good afternoon to those of you streaming in. We'll get started shortly. Thank you for being here with us today. Happy Friday. If you're just joining us, we'll get started shortly. Thank you for being here. I understand we have some friends from the Toledo Bar Association and the Dayton Bar Association. Welcome, welcome. Looks like we have a pretty good amount of people on so far. And I know we have a lot to cover. We're a couple minutes in, so let's go ahead and get started. Good afternoon, everyone. My name is Dominica Essie. I'm the education manager here at the Cleveland Metropolitan Bar Association. Thank you for tuning into today's program presented by the International Law section of the CMBA. Eligible for 1 hour of CLE credit. In order to get that credit, you have to do two things. Complete the poll that will appear on screen during the session today and complete the survey which will be emailed to you upon conclusion. If you have any questions, you can drop them into the chat or the Q&A at the bottom of your screen and we will address those either as they come in or towards the end of the hour. So don't hesitate to drop those in and we'll do our best to get to everyone. So with that, it's my pleasure to turn it over to Stacy Cozart Martin, who is on the Executive Council of the International Law section. She's been very busy practicing immigration law, of course, as well as volunteering her time to put together these amazing programs. Stacy, thank you so much for being here. I will turn it over to you.
Absolutely. Thank you so much, Dominica. So I just wanted to first give you kind of a roadmap of where we are going to go today, which is the intersection of immigration law and criminal law. If you practice in either area, you will know, unfortunately, that there is a very large overlap in these two areas. In addition, we are having some further programming that may interest you. We have a habeas training on Monday, also virtual. We have an AI and surveillance and immigration law on April 23rd. We have a labor and employment law intersection on May 7th. And then we are doing a mid-year roundup on June 10th. So please pay attention. Hopefully we will see you all soon. But without further ado, I'm going to hand it over to our experts today, Sarah Owens, Jessica Larson, and Ashley Jones, who will do their own intro. If you have questions, please drop them in the chat as we go, and I'll make sure to address them. Ladies, thank you.
Thanks so much. I guess my name was said first, so I'll go first. I'm Sarah Owings. I am not in Ohio. I'm actually a Georgia practitioner of immigration law, but of course, immigration law is administrative law, so I am licensed to practice in all of the immigration courts. And I, thank you so much to my friends for welcoming me to come and talk to you guys about some of the consequences of criminal activity and some of the ways that this overlaps.
I'm Jessica Larson. I am in private practice here in Cleveland, in immigration as well, doing primarily removal defense, but also some family-based immigration, asylum, that type of thing.
Good afternoon. My name's Ashley Jones. I'm a criminal defense lawyer here in Cleveland. I am part owner of a firm called AJLJ Law. We represent mostly state criminal defense cases and have the opportunity at times to represent folks who may have immigration warnings. And so those are some of the things that we'll be talking about today.
So this is my slide, so I'll probably talk about it, I guess. One of the things Stacy asked us to talk about, because we weren't really sure exactly who was going to be attending, how much in-depth knowledge they would have of different areas. So, within the immigration law world that Sarah and I practice in, it's almost entirely administrative civil law. But there are some offenses related to immigration that are criminal and are prosecuted typically within the federal district courts around the country. A lot of these, especially these first two, are down close to the border most of the time. So the first one is illegal entry, and then the second one, illegal reentry, meaning you've done it at least twice. And those are criminal offenses. They can be prosecuted by the district attorneys, and that's where the information comes from. You know, the first one's a misdemeanor, the second a felony. And we have seen those prosecuted throughout, you know, the time I've been an immigration lawyer. It does tend to vary through various administrations. Additionally, like when I personally have seen a client come to me with a conviction, typically for illegal entry, it does seem to, I think, typically be single males. You know, there does seem to be patterns within the types of respondents that get referred for prosecution as opposed to just being referred to immigration court proceedings. But, you know, and then the next couple of offenses I listed here are technically within the law as criminal offenses. They have not historically been prosecuted. These are two offenses that have come up recently under the current presidential administration as something that has started to be enforced. I personally haven't seen a lot of it, but we do see news stories about these two things. One is that all foreign nationals have to register with the government after 30 days here in the United States. If they don't, then that's technically a crime. And then they also have to notify the government if they change their address. And then a couple more here, you know, marriage fraud, other types of immigration fraud. They can be prosecuted. I have not seen it happen often, but it is in the law. And then failure to depart. So this is after somebody has a final order of removal within the civil system, and then they fail to depart after that's made final. It can be prosecuted as a crime as well. All right, Dominica, you want to go to the next one? This is something once we started seeing all these new possible criminal offenses that we needed to worry about, we started thinking a lot about the statute of limitations on those, because often we're talking within the civil context, the civil immigration context, about how people entered, where they've lived, you know, and so are we, for instance, when we disclose on various forms, talking about how the client entered, are we admitting to a crime as well as, you know, part of the civil proceedings? Maybe, right? It's less dangerous if it happened more than 5 years ago, right? Because for the criminal, within the criminal context, you do have the statute of limitations. So that can kind of guide thoughts on that. And then the civil fines and penalties, I put this in here because that is something I have seen. I'm not sure, Stacy and Sarah, if you've seen it, but it's a new initiative, again, under this presidential administration, to send out letters to foreign nationals with final orders of removal who have not left for whatever reason, telling them that they owe millions of dollars in fines because they're charging them almost $1,000 a day for staying beyond that order. So it's another tool that the administration is bringing out to see if they can put it to use to achieve their, you know, goals of motivating people to leave the United States. And then the last one there, just so because it's a big deal, right? Removal proceedings, essentially there is not a statute of limitations. You know, I see cases brought all the time for things that happened 20 years ago or more, right? So with immigration court civil proceedings, which is the next slide, there's no statute of limitation. You can go to court for something that happened 30 years ago. So that's the third slide here, civil immigration offenses. So when you guys read in the news about immigration court and immigration judges, those are all located within the Department of Justice, an administrative agency, and it is civil. It is not criminal. And that is primarily where you see the enforcement of our immigration laws, right? Most people are not charged criminally if they cross the border without inspection, but they are placed, if they're caught, which most of the time they are, they're placed in civil removal proceedings. And so also when you read in the news about the levels of detention of immigrants in removal proceedings, that is technically civil detention. It is not criminal detention. It is civil detention. But for the people that are there, I'm not sure that the difference makes as much of a difference. When a foreign national is placed into civil removal proceedings, they are typically charged under one of two statutes, which are listed there. One being people who are inadmissible, the other being people that are deportable. And often the grounds charge would be being present in the United States without being admitted or paroled, having no valid entry documents, having come in with a visa of some sort, but staying longer than you were supposed to or permitted to. And then certain criminal convictions, which can apply to people that do not have any lawful status, but also people that do, like lawful permanent residents. And then various types of immigration fraud. That's not everything, but it's a lot of what we see. All right. I think I'm turning it over.
Yeah, I think you are. I'll talk about some of the criminal grounds of removability, what Jessica was describing, some of the charges that you can see in the civil immigration proceedings. And yeah, I think it's just important to recognize if you're on like a CJA panel right now, you might see more of these cases regarding people that are doing, unlawful entry, sort of criminal cases. But by and large, these are going to be cases that show up in immigration court. And there are a few big categories. Crimes involving moral turpitude. It's a really, to quote my friend Heather Prendergast, who I believe is somewhere in this group, it's a really squishy definition. It's defined by case law. There's not one definition that says what a crime involving moral turpitude is. So lots of things can fall under that definition. It's supposed to be anything base, vile, depraved, or that shocks the conscience. And there can be a lot of overlap between those things if you think of like theft crimes or crimes of violence or any sort of activity like that that's not just a regulatory offense like a drug crime, where something could be a crime involving moral turpitude, but then depending on the sentence, typically it could also be an aggravated felony. That last category that we have listed here, that definition is at 8 USC 1101 A43, or in the INA, it's INA 101 A43. And there's a lot of listed aggravated felonies. But most of those are defined based on kind of what the sentence is. So for theft crimes, it's theft crimes that have a sentence of a year or more. For crimes of violence, same thing. So if you have a year of confinement sentence, that is the same idea. Fraud crimes where the loss to the victim is over $10,000. So it's a little bit more specific, kind of getting down into the nitty gritty of what actually happened as opposed to just that kind of generic CIMT definition. Separately, and this is important to point out, there's sort of like two different ways to be in removal proceedings. You can either be in sort of inadmissibility proceedings where the charges are found at section 212 of the INA that says you are not yet, like you're not admitted to the United States and you're not admissible for these reasons. So people that don't have status or have left and done something that causes them to be out of status. And they're defined sort of differently. They don't have some of these sort of like underlying definitions like people who are in 237 proceedings where they're charged with having done something that made them lose their status, right? Like either they overstayed or if it's a criminal ground under 237A2, it is a section of the law that talks about, specifically A2E talks about domestic violence crimes, stalking, child abuse. That is a separate section as opposed to kind of being this sort of global chunk for people who are inadmissible. Firearms offenses are also defined under Section 237, but not under 212. Prostitution comes up on both ends of it. It actually is in 212. So there's other crimes related to prostitution, and it also depends on whether or not you are involved in prostitution as the person who is receiving money for a commercial sex transaction or the person who is paying for or arranging. So like pimping obviously is a different crime and can be an aggravated felony. All crimes relating to drugs, although drug laws have changed in many states at the state level. Unfortunately, if you deal with non-citizens of the United States and they want to go open up a marijuana dispensary, you should be telling them no, because that is still a major issue that can get you into trouble under the immigration laws for the civil process. So it can still be considered a crime relating to a controlled substance. And the waivers are not very generous. If you are not a citizen and you're not a permanent resident seeking residency, the only drug crime that is waivable is a single offense for simple possession of marijuana less than 30 grams. Then it's possible to get a waiver based on a really complex process of showing hardship to a qualifying relative that's a citizen or resident. But otherwise, that is an inadmissibility ground that will not go away and makes you inadmissible for life. It's a little bit different in the context of somebody we're trying to kick out that hasn't gotten, or that already has their status. But drug crimes, by and large, if you have more than one drug offense of any kind, it also subjects you to mandatory detention. So it's a big deal, and I don't recommend engaging in those kinds of businesses, although it can be quite lucrative these days. It's not the place to put your money in if you are not a citizen. And aggravated felonies, I kind of talked about that. There's a bunch that are important to know. And really, it comes down to like, if a case lands on your desk and you see these criminal convictions, then you need to go ahead and figure out what section of the law immigration is going to charge them under, what the potential impact of it is. And so that's what we're going to talk about. I see we had a question in the chat. What if the person uses for medical with a prescription? I am like, how is that going for you guys? Jessica, are you seeing these cases where people have prescriptions and it's not recreational, it's prescribed by a physician for a health reason? Are you seeing these come up?
I haven't personally had to look into it or deal with it myself. If they're already here, could they be convicted of a crime related to a controlled substance if that's the case, if they have the green card or whatever? I think that's a little more questionable. If you don't have status and you're applying for something, I think you have a problem, because even though it's legal under the state law, that substance is still illegal under federal law, and so the question is, have you ever violated a law relating to a controlled substance? And I think the answer is, yeah, I've violated the federal law, not the state, but the federal. What do you think, Sarah?
Right. I agree with you. I think that it comes up when you have people who are seeking benefits in the immigration system, right? So one of the big ways that this administration likes to go after people is they're re-reviewing. They're reviewing hard to look at your prior applications and what you said when you said it. And so if you have somebody who has a medical card, right, and they have gone through the process of seeking residency or seeking citizenship, and they have said no on all of these drug questions, well, then it's not just the fact that they used, it's the fact that they lied about it. So you have this other element of a layer of problems that could cause rescission proceedings or denaturalization proceedings based on the lie. That's why if it's possible to not involve yourself in this way, if you are not a citizen, I would highly recommend avoiding that mess, because then if you have to answer yes to those questions, then you have a lot of explaining to do, and you have to look at the timeline and what the limit of the look back for the benefit that you're seeking is on your good moral character, and arguing about whether or not it's a regulatory offense and is it really reflective of bad moral character if it's medicine. You can avoid a lot of that by, finding some other way to take treatment until you acquire citizenship, and then you don't have to worry about it the same way. So yeah, I think we can go on to the next slide. Yeah. So I wanted to talk about what it is to diagnose a conviction and the way that things are done, because we're in this world now after some Supreme Court decisions in the last decade and a half. We had DeCamps in 2013. We had the Mathis decision in like 2016, where we have this process of looking to see if a crime is a categorical match to figure out, is burglary really burglary? It turns out that where I am, theft crimes in Georgia are not actually theft crimes. It's not theft because the way that this works, it's a 3-step process where to figure out whether the definition under immigration law, your conviction at the state level, is a conviction for immigration purposes. You compare the generic, like generic definition in the federal definition of what the crime is with the state law, right? And if it's a categorical match, meaning everything is completely the same, if it's just that's it, then you are okay. Yeah, that's absolutely going to be run afoul of the federal immigration definition. But if it doesn't, and a lot of times they don't, because there will be different elements and different things that are included depending on the state that wrote it. In Georgia, the theft definition has no permanent intent to deprive. Like there can be no, you can commit theft without actually having the intent to permanently take something, and because of that, it's not a categorical match and it's considered overbroad. So because it's overbroad, things cannot be necessarily a theft crime that causes it to run afoul of the aggravated felony definition in the law. So it's a way to look at it. Just make sure that if they're not exactly the same, then you may have a way to attack it if you're doing these diagnoses for immigration purposes. And I don't know how many folks in this room are going to be looking at things from that angle. This may be a thing where you're looking at things from the lens of being a criminal defense attorney. And if that's the case, then you don't have to get too down in the weeds about this, but you need to have a friend that will do that with you, so that if you have a non-citizen client, that they can make sure that they're not going to wind up down in the weeds in immigration court with the wrong sort of plea and sentence. But yeah, so you compare the statutes. Are they the same? Okay, then yeah, it's a problem. If they're not the same, then what's your wiggle room? Then it comes up to whether or not the statute is divisible, right? And by divisible, that means whether or not under the Mathis test, whether or not there are separate elements that can be used to run afoul of it. So the way that they look at that in I think it was in DeCamps, they talked about how I think it was if it was shoplifting. No, excuse me, it wasn't shoplifting. It was burglary. So if the burglary statute in DeCamps said that if it was you were violating the statute by the lawful entry or the unlawful entry of a dwelling, if it could be one or the other, but those are two separate fact sets that could lead to the same conviction, then it's divisible, right? Because you have these multiple different ways of violating the statute, right? But if it comes down to the means and not the elements, right, where it's not really the facts of like what happened, but the means by which it happened, was it, a barn? Was it a house? Was it a this? Was it a that? Like, then it's not considered to be divisible. They made that clarification in Mathis that it was not necessarily a way to run afoul of the statute in a way that was a categorical match. And if things are overbroad, then you may have some wiggle room that says that something is not in fact a conviction for immigration purposes that could make you deportable. It's complicated. It's kind of weird. I do recommend having a friend that can help you define these things. We will talk about some examples of how this came down later on, but then you decide then based on whether it's a categorical match or not, whether or not the court can then look at subsequent documents of the record of proceedings to see from the criminal case how the statute was violated and whether or not it is a match that makes somebody removable or has the effects of having a certain kind of conviction for immigration purposes. I see we've gotten some questions about dismissals. And we'll get to some of those issues later on when we talk about like ways to plead through a case. And so we'll talk about that stuff then. I think we can go on to the next slide. I wanted to touch on this. I could spend 2 hours talking to you about this, so I'm giving you a very condensed version of it. But just to kind of show you how this plays out, this is the realistic probability test. And so when you get to that like idea of if it's divisible or not, is it a categorical match? And then you have to get to the question of whether or not, if they can only look at that certain limited amount of documents of just the conviction itself, is there a realistic probability that you can violate the statute with conduct that doesn't run afoul of the immigration law? So it's a question of, is there a realistic probability, not a theoretical possibility, that the state would apply its statute to conduct that falls outside of that generic definition? We can go on to the next slide. And I wanted to show you guys this one because this is it's an unpublished case from Ohio, or from the immigration court, but it's an Ohio statute to show you what can happen. This was a case where somebody had a conviction for obstructing official business under the Ohio code, and it was found to be not a crime involving moral turpitude because the attorney found examples of how that statute had been used to prosecute people for putting coins and being like a little parking meter angel of putting coins in a meter as a police officer was busily writing tickets. So that is not considered to be crime that shocks the conscience. It's not base, vile, or depraved. And under that categorical approach and that minimum conduct consideration, it was found to be not a crime that caused that person to be ineligible for the benefit that they were seeking. Okay, we can go on to the next slide. So I wanted to make sure you guys could see how this played out. This is another example, right? Because of motor vehicles, okay, the handling of a firearm in a motor vehicle, it's not a firearms offense, even though it has the word firearm in it, it's not, because the state had prosecuted people for possession of antique firearms. And antique firearms are not considered to be firearms because of the way the definitions work out in the federal definition of what is considered a firearms offense. So same idea. These are kind of the ways that you can have wiggle room under the statute. And when you're looking at this categorical versus modified categorical approach, modified categorical, that's when it gets hairier. That's when you get down into what the record looks like. And so it can be a little more complex, but I'll shut up now about this. I think we can move on and talk about where foreign nationals are encountering ICE. Who is going to take this one? I think Jessica, is this you?
You can do it. Yeah, I did the slide.
Okay. Yeah.
This was something that I was asked at another presentation I was working on, which is, where are people in danger of encountering ICE? And these days, it's a lot of places, right? I would say a lot of my clients, the reason that they were placed in removal proceedings or encountered by immigration is at entry, either because they crossed the border illegally and got caught shortly thereafter, or when they were coming in through a border port of entry, something raised the concern of immigration officers and ultimately resulted in the initiation of removal proceedings. Another big way, which is obviously the most relevant to this presentation, is in connection with criminal proceedings. So whenever someone is arrested and their fingerprints are taken, those are automatically sent to the Department of Homeland Security through this program called Secure Communities. And so immigration is constantly looking through that information to try to determine, are any of these people that have been arrested people that don't have status or can be placed in removal proceedings because of whatever's going on with their criminal case. And if they do identify the person as somebody that should be placed in removal proceedings, then they will, you can see that third little bullet point, typically place a detainer on them. It's called an ICE detainer. And so what that says is that the local jail, once that detainer is placed, the local jail does need to hold the person for up to 48 hours, although in my experience, they often will hold them longer in violation of the law to wait for ICE to come pick them up and process them. And then, of course, also within the news, especially within the last year or so, we've seen news stories about people going to their criminal court hearings for one reason or another, and ICE officers being there to detain them for removal proceedings. And then, another big one, traffic stops. Traffic stops or other transit checkpoints like bus stations. Bus stations are big. Or people, even ICE officers getting onto buses, asking people for their documents. But that's a huge one, because many people who are here without status do not have a driver's license. In Ohio, you can't get one unless you have a work permit or other documentation. And so a traffic stop for failing to completely stop at a stop sign can become a really big deal when you don't have a license to produce for it, which then leads the officer to inquire about immigration status, which can then lead to calling ICE. So I see quite a few people encountered through traffic stops. And I know, Stacy, you mentioned when we were preparing, do you mind telling what you were seeing? It was like on I-90, right?
Yeah, so there is a CBP facility out in Sandusky, and the Border Patrol have been sitting on I-90, basically stopping, usually for speeding because it's a pretty open area, but then are stopping now based upon the color of your skin, right? Because now we can do that. So I would say if you're on 90, if you are close to the border, which Ohio, obviously, parts of it are very close to the border, you want to make sure that you're careful and not driving if you are undocumented or don't have proper documentation.
Another place that people commonly get detained is at their ICE check-in appointments. So for quite some time, people might be placed in removal proceedings but not detained, right? But they're released on an order of supervision or some other, check-in document. And so they have to go into the ICE office every 6 months, every year, just to check in, say, hey, I'm here, this is my address, I know my next court date is X date, I'll be there. But especially within the last year, we've seen a lot of people who are doing everything they're supposed to do. They've filed their forms, they've gone to their hearings, they usually have attorneys, they're working their way through that system, and still ICE is detaining them to put them in detention while those proceedings continue. So that's a big point where people are afraid to go to those check-in appointments because they don't want to get detained, but there's not a good alternative, it's tricky. Immigration court hearings, of course, people have been hearing about that a lot on the news. It seemed to me, at least here in Cleveland, it was very heavy in the early summer of 2025, June-ish, roughly, May, June, July. And then it has lessened. I believe there was litigation about it. How's it looking down there in Georgia, Sarah?
We were having the same thing. We were having people picked up, but I think under Markwayne Mullen, now that we have a different DHS secretary, it seems like they've realized, or at least acknowledged, they probably always realized, but they've acknowledged that policy is really bad and it's not, in the spirit of the law and due process. And so they have announced that they will be stopping doing that, or that they have stopped doing that. And maybe it was a bit of a mistake. The same way they said, oh, well, in immigration raids, the using of administrative warrants are not actually sufficient to beat down a door, that you can't do that unless you have a warrant that's judicial, that's signed by a judge. Otherwise, ICE doesn't have that ability. Previously, they were doing that the same way they were picking people up at immigration hearings. And allegedly, they're going to stop doing that. So we'll see.
We can hope. Yes. And that's, of course, related to that last point, immigration raids. We have historically had raids here in Ohio, often nurseries. Where else, Stacy? Maybe like a dairy farm.
Yeah,
mostly agricultural.
Mm-hmm.
We haven't. I haven't heard of like major operations going into like the homes and neighborhoods here in Cleveland, but it is something you hear about in particular in like Minneapolis, Los Angeles, that kind of thing. I don't know if you're seeing a lot of that, Sarah.
Well, so we had the LG Hyundai raid, where they took 350 South Koreans into custody while they were actually serving a judicial warrant, a search warrant that was looking for 4 people from like one subcontractor for one part of this facility, but then they had a lot of collateral arrests. And yeah, I think the bottom line for this is that there's this push because of the numbers. ICE has been instructed to do big numbers. They're supposed to complete a certain number of arrests and detentions per day, and they're supposed to keep a certain number of people detained. And so that has incentivized them to try to find as many sort of easy encounters as possible. So that's why you're seeing people picked up at ICE check-ins. And then if they can cast a broad net during the course of those raids, or, go into a restaurant and try to see who runs and then go grab everybody, that kind of situation is happening more. And I can anticipate that will continue to happen through the rest of this administration.
Yeah, that is what we have been hearing on the ground here too, is that there are, you need the officers are being told they need the numbers. Okay, next slide. I think this is you, Sarah, yeah?
Yeah, so we wanted to talk about what this means as far as keeping people in detention, right? So we've talked about the kind of ways people are filtered into the system and then how they're staying there. You're probably all familiar with the Laken-Riley Act that was signed into law shortly after Trump became president this time around, and it amended the law to increase the categories of who is subject to mandatory detention and removal proceedings. People who have crimes involving moral turpitude, who are arriving aliens, or who have multiple crimes involving moral turpitude were already subject to mandatory detention. People who had aggravated felonies or multiple controlled substance offenses, those sorts of things, and terrorism. If you were suspected of terrorism or national security threats, those people already were. But now they have made additional categories for people who have entered the country unlawfully. And if you don't, have valid entry docs or made misrepresentations at the time of your entry, those folks are all subject to mandatory detention. And then they added in this other category related to criminal conduct that it doesn't include convictions, right? So I think we're all pretty much used to a system of people being innocent, presumed innocent until otherwise determined by a court of law. That has gone out the window with the Laken-Riley Act. So now it's people who have arrests or as well as convictions for burglary, theft, larceny, shoplifting, assault of a law enforcement officer, or any offense resulting in death or serious bodily injury to another. Which, you think about it, if you think about vehicular homicide, when it's involuntary, that would still run afoul of this statute. So if you get in a bad car accident and, have bad luck where someone dies, that could still subject you to mandatory detention under this law. Let's go on from here, because those are definitely things that are legally now considered to be crimes that make you subject to mandatory detention, where an immigration judge cannot give you bond. Next slide, let's talk about what we mean by pseudo-mandatory detention. Okay, so historically, the way things have worked, people who are undocumented in the United States are in removal proceedings, and they are subject to detention under INA Section 236A, which is the section of the law that says you may be detained, right? And this is somebody who crossed the border and then has a subsequent encounter with immigration. It could be 5 years, 10 years, 20 years later. You've got your house, you've got your car, you got your kids, you got all your stuff. You've been here and you may have eligibility for relief, but you also have these ties. It was possible to go to an immigration court in those scenarios and seek a bond for that person, right? Under the policy shifts that have happened with this administration, first the DHS put out some memos last summer, last May. It was around the same time as we can also, break down your door with an admin warrant. They said, okay, Todd Lyons put out a memo that talked about how, all right, we're going to make it so that anybody in that category, we're going to treat them the exact same way as someone who is an arriving alien. An arriving alien is a separate section of the laws under, instead of, it's 236A is the section for people who are, the regular folks who are just straight, entered without inspection and encountered later. 235, so INA Section 235 deals with people who are at a port of entry. So it's people who are encountered at the time that they're knocking on the door of the United States and they don't have the proper documents. The law allows for them to be detained through the course of their proceedings, because We should be able, in a lot of those cases, to use expedited removal and simply remove somebody if they don't have the right paperwork. But there still may be reasons why someone's knocking on the door to come in. Usually it's because they are, in fear of their life. Something terrible has happened to them that they need to explain to an asylum officer. And if they do that, and the asylum officer agrees that, yeah, that actually is a case that forms the basis of an asylum claim, they're allowed to present that asylum case to an immigration judge. Those folks are subject to mandatory detention. An immigration judge can't give them bond, and the only way for them to get out is through ICE's parole authority to give them conditional release. They're not giving conditional release to anybody these days. They're not letting folks out if they have the ability to, because they need to keep people in detention to make money for their friends. The way that it works right now is that ICE, under these memos that have come out and then subsequent court decisions that back it up in the immigration court system and the Board of Immigration Appeals, they say we're going to treat everybody who came in at any point and then was later encountered the same as if you are knocking on the door right now and consider you an arriving alien, and strip the immigration court of jurisdiction to give you bond. So that's why we say pseudo-mandatory detention, because it's not actually mandatory detention. And you know who agrees is most federal district courts. There has been a massive rash of habeas filings. People are filing habeas corpus and seeking declaratory relief that people who are in 236 custody situations should be considered that way, right? So I think that I was talking to a small group this morning, and I think it's something like 34,000 habeas petitions have been filed on these sorts of issues since January of last year. Around 8,000 of them have been decided, and pretty much all of them are decided favorably. Of course, now the Fifth Circuit and the Eighth Circuit Courts of Appeals have sided with the administration and said, we agree, we're going to pretend the sky is green because you want us to. We would also very much like to be the contestant on the next Supreme Court Justice of the United States. So please, we'll agree and we'll let you have this. And so that's kind of what's happening in the space of detention and bond. You first have to file a habeas petition, get that granted, and then you can go have your bond hearing and duke it out in the immigration court. So we anticipate additional policy shifts that are going to be not favorable to foreign nationals, and that will be very favorable to the Geo Corporation and the Core Civic Corporation that control a lot of these private prisons, who are getting a lot of money from our tax dollars based on the idea that we need to suddenly detain all of these people and subject them to mandatory detention. Okay, I think that's all I have to say about that. I'll crawl off my soapbox and we can go to the next slide. Yeah, okay, sorry. We'll reiterate. You have to find out, and I guess this is really more for the criminal practitioners in the room, right? If you have somebody who you are representing in criminal custody, and then the question of if there's an ICE detainer, if they're a non-citizen, you need to figure out what the bond jurisdiction is going to be before you pay any criminal bond or conclude that case, because the clock is going to be running and you need to think about those consequences prior to the family paying the bond, and then suddenly they don't come out of custody and they're stuck for that 48-hour hold, and then it's been a week, and then all of a sudden ICE finally shows up and takes them. You need to do that then, not later. Okay. All right, for real, I'm off my soapbox. Who wants to take this one?
I think I did this one, but I'm going to go very quickly because I want to get to Ashley. Common criminal issues that we see. Yes, we were all talking about this when we were preparing. What are the things that we see most frequently with our clients? Traffic issues are big. They don't normally actually themselves cause immigration problems, but they cause you to come to the attention of immigration and get placed in removal proceedings, right? DUIs are problematic. Again, it doesn't normally constitute a crime involving moral turpitude, but particularly up here, and I believe countrywide, it presents a pretty big problem in trying to get a bond from an immigration judge, because they have to look at whether you're a danger to the community. If you have a recent DUI, the judges in Cleveland typically find that you are a danger to the community, because they don't want to be the one that lets somebody out who then gets in an accident, right? So problematic, not for immigration status typically, though it depends, but definitely an issue for bond. Petty theft, shoplifting, a lot of the times it does constitute a crime involving moral turpitude. depending on the type of offense, you can maybe fit yourself into a petty offense exception, which can help out within the immigration context. Prostitution. I looked into this recently for somebody. Stacy mentioned this. Like all of a sudden, all of our clients are coming to us with prostitution convictions. There's been a wild investigation, and mine are coming from Northwest Ohio right now. But anyways, there's a board case out there that like a single act of solicitation is not enough to be engaging in prostitution for that ground of inadmissibility, but it usually does constitute a crime involving moral turpitude. So you have to be careful. Domestic violence, I see this come up frequently, right? And one of the concerns with this is that even if you plead to like say like a simple assault, the case law on it within the immigration context is that you can then go look at the rest of the documents, even the police reports, that kind of thing, to determine what the relationship of the victim was to the person who is convicted, right? So you can try to keep it out all you want, but that relationship is subject to what they call the circumstance specific approach, which lets in a lot of stuff, right? And then drug possession, drug trafficking, this gets really tricky. We already talked about marijuana. I won't belabor it, but like, especially with the marijuana, I've had clients get their tickets, for the low level marijuana stuff and just pay them like it's a speeding ticket, right? I'm like, don't do that. Don't come to me after you've done that, right? That's a problem. So again, just reiterating, even marijuana is an issue, and anything related to sale, even if it's like a very small amount, can be really problematic because it does get you into that trafficking category. All right, let's go to the next slide.
Before you go, Jess, there was a question about, is there a human trafficking exception for prostitution offenses?
So that gets into some nitty gritty about the particular context, right? There are various T visas for victims of human trafficking, and there are waivers that could waive any problems that you have related to the prostitution. So I guess my very overbroad and not at all well thought out response is yes. If it's related to human trafficking, there are some things to look into to try to address that. Tara, you have anything more on that?
I think it's sort of like in general, when thinking about the way removal proceedings work, there's two phases. If you're in this process of somebody that they're trying to deport from the US, the first phase is where the government has to prove the person is removable. Their only burden is to say this person's not a citizen, they're a citizen of wherever, they have this conviction, and we say that makes them deportable. And if those things are met, and that's like the case, if you actually have a conviction for prostitution, regardless of whether you were trafficked or not, hopefully your criminal attorneys on this call will be amazing and do a really good job of defending people in those cases. That is something that then, you could still have that conviction, right? And then it becomes a question for purposes of phase two, when the government can put its head down, go to sleep, shop online, look for other jobs. And we have to really kick in our job of defending the person with whatever relief is available. And that may be a T visa, T for trafficking. It could be someone who's eligible for a U visa. I'm looking at, so what about VAWA and the victim also faces a counter by the abuser? Do you mean a counter charge by the abuser, like the abuser is making allegations against them? Same thing, that's really part of relief. It goes to whether or not somebody is seeking relief and what that relief is. And so it's a consideration for the case, but not necessarily all on its own, something that will fix it, right? If you have that conviction, it still is a conviction. I think we can probably go to the next slide. Yeah. And I think actually, can we jump one more? I think I've mixed these two slides up, and I wanted to do what is a conviction, which really kind of is at the heart of what that question was too, I think. And Ashley, do you want to take this one? Do you want to talk about what's a conviction, or do you want me to address this and then you jump in on the post-conviction stuff?
Yeah, this is your definition and world of
Okay.
conviction. So, yep.
Yeah.
Go ahead.
Yeah. So this is the definition. This is the definition of conviction in immigration law. It's a formal judgment of guilt or a plea of guilty or no contest, or an admission of sufficient facts to warrant a finding of guilt and some form of punishment, penalty, or restraint on liberty. You have to have both those things. If you do not have both those things, that is not a conviction. So then the question becomes, how does this interact with things like diversion and deferred prosecution? Jessica and Ashley, do you guys want to talk about that in the context of Ohio law and how this comes up? Like,
Yeah,
what does that look
Sure, I
like?
think
Are
that's
those convictions?
for
Yeah,
Ashley.
I,
Yeah.
great. Yeah, well,
yeah, and I
time
think
warp back to the previous one.
probably move a slide, and we might get into that maybe.
Okay, yeah.
Okay, so
Yeah.
and we had a question about this in the chat as well. So good timing. So a lot of times in the criminal world, a diversion program or a first offenders program is a good option for someone's criminal case, which does not mean that it is a good option for their immigration case. And I think I have this on a different slide, but I will say it now and probably then because it's so important that if you are representing someone who is not a citizen, you must refer them to an immigration lawyer. Now, I don't know that the rules of professional conduct say that. That's not my version of must. But you really should. And you should do that in writing. And you should follow up with your client to see if they called Jessica or Stacy or Sarah when you gave them that information so that everyone can be on the same page and hopefully get a great result in both criminal court and an immigration court, because that certainly is possible. And there are a lot of, Jessica and I will work on cases together. Although it's been quite a while since we have. So hopefully we're kind of summoning the universe here. But you can have that collaborative approach where everything can be okay. So diversion typically requires an admission, a guilty plea, or a no contest plea, which in this context would be just like pleading guilty. It's the same reason why Jessica said when clients will pay a minor misdemeanor marijuana ticket, which could exceed the 30 grams, which is why she probably wouldn't want him to pay it anyways, but it doesn't necessarily mean it's less than 30 grams. So that's when you go and pay that, just like when you pay your speeding ticket, you're pleading guilty. They're just making it easier for you to, because the government likes to make things easy like that. So that's why these admissions are problematic. And so it does not matter when it comes to immigration court, and you guys correct me if I'm wrong, but it does not matter one lick that your case got dismissed. Woohoo, congratulations. It's not good. And you've put your client in a really bad situation. So I guess that's why they picked us all to be on this, because Sarah and I both like soapboxes. So I guess that's good. So it doesn't matter the case got dismissed. It's really irrelevant. So what can you do? Hopefully you have a relationship in this court or with certain prosecutors where you can say, hey, my guy cannot plead guilty. Here's why. Here's the letter from the immigration lawyer in my file about this. And can we do all the same things that we do in diversion and maybe some extra things, but we just don't want to do in admission because we can't. And we're still getting to the same point. And sometimes people are like, well, we just don't do it that way. That's not the way we do things, right? These are different circumstances. And I think a lot of times, especially kind of just like public sentiment right now, in my experience has been that a lot of people are willing to do things a little bit different or cut a break a little bit different than how we typically do it, because they're not trying to jam somebody up, because of just how they are interpreting the world, seeing the world, their own personal views. Same thing with intervention in lieu of conviction. Intervention in lieu of conviction I have listed here is under 2951.041. It's a statutory construction that's similar to diversion, but it essentially is saying that someone's drug use or their mental health essentially contributed to the offense. Were it not for that, this wouldn't have happened. It's similar to diversion that you don't quite have to be a first offender, but you have to be pretty close. And same thing, though. You plead guilty to get into ILC. Whoopsies. If you take nothing away from my portion of this, and if you take that away and you didn't know that before, I think we will all agree that this was a raging success. Okay? We got a question, it looks like. Let me see. Practically speaking, would you try to negotiate with this with the prosecutor off the record or the judge? Yes, I would try to negotiate it with the prosecutor first. It's a little bit trickier on the ILC. It's easier to negotiate these kind of more creative things on a diversion situation. And then, if you need to get the judge on board, fine. But I'd rather have the prosecutor on board first because it's their case. And the judge is probably going to listen to what the prosecutor wants to do anyways, more than what I want to do. So that sounds to me like the best way to do it. Good question, though. Again, doesn't matter. At the ILC is always 1 year. It has to be a minimum of 1 year. It's built into the statute. Doesn't matter that the case gets dismissed and you could seal it. Really doesn't matter one bit. So you're going to have to do something different. Next slide, please. I'll just mention this briefly, and Jessica and Sarah and Stacy, I know could talk about this. Expunging, of which we actually do have true expungement now in Ohio fairly recently, the past couple of years, and sealing. Your immigration lawyer probably does not want you to do that. Well, I know they definitely don't want you to do that. If you do it, maybe they would say get a copy of the file first or the docket, maybe, but probably still don't do it. And maybe that's a situation again where you call up your immigration friend and say, hey, this person called me about this and what should I tell them? And they're going to say, don't do it. So our first offender program involves a court referral to diversion without a plea. It is not a deferred finding. I'm confused how it's not a deferred finding if it's diversion and they have some things to do. But I guess I would say, without knowing more, if there's no admission, I mean, you can't help that they're being charged, right? And Jessica and the immigration people will tell you, like, sometimes these police reports are big problems, right? And there's nothing that any of us can do about that. I can't help that you're charged and you're in my office. I can help how I try to resolve the case. It's a pretrial diversion. There is no entry of, so if there's no admission, great. Maybe that sounds like a great option. I would not anticipate issues. Can someone clarify whether in Ohio dismissal under a diversion plan or ILC differs from a dismissal of charges with prejudice? What I mean is, from an immigration standpoint, what about cases that were overcharged or charged incorrectly? Well, it's different because that's tricky. It's different because in diversion or ILC, there's never a conviction, which is kind of what always is what the appeal of it is. But I'm not quite sure that I can answer that question, Jennifer, but I'm happy to talk about it. Or someone else knows, you can please answer. I don't know. I'm not sure. I think it's my last slide. I have 2 minutes. I'm going to do it quickly. I'm sorry. Yep. Okay. So sometimes things get messed up, and you have to try to withdraw the plea. 2943.031 is where you would be looking to in this situation if the immigration warnings were not given. The immigration warnings are in the statute. This is it right here on the slide in your material. That is what the judge has to say on the record. And it's different than when you're trying to withdraw a plea generally in criminal law, trying to say that it's to correct a manifest injustice. This is a completely different statutory construction than that. Next slide, please. I'm not going to go through this because we're really low on time, but there needs to be the warning. There needs to be a transcript, right? And something that is sometimes beneficial is that transcripts, for whatever reason, and no one ever seems to want to fix this, which is helpful. I'm surprised that no one's ever just been like, we should probably keep these things, but no one does, so we don't have them. And now, especially with courts like not having court reporters, there's like a national shortage of court reporters. It's a really weird thing. It's a dying job. Like things are audio recorded and like it's all messed up, right? And you can't hear and it's not clear and it wasn't working. And so in the absence of a record that the court provided the advisement described in Division A, and if the advisement is required by that division, the defendant shall be presumed not to have received the advisement. That's the part in this that you really should read and look at. That's the important one. Deep breath. All right. Last slide, please, I think. Okay, what about this? You go to a lot of municipal courts, misdemeanors. They like you to sign forms. They think that that makes it easier and that's better. What about that form? Okay, but you still have to talk to the defendant, the accused, on the record. And then we don't have a record, so we still get back to subsection E is how I have had success. I just did this for a client. And we're able to get these cases reopened and then dismissed because they couldn't prosecute them. They were from 20 years ago. Issues that I put here, even if there is a form, I would be like, well, do they speak English? Can they read? Was there an interpreter? Did they understand what the form even said? And those are some issues that you could maybe get into. I know we're right at time, so I will stop talking. I think I hit everything I needed to hit. Oh, there we go. All right.
Anyone has any specific questions, they can definitely reach out to Jessica, Sarah, or Ashley. It's a very confusing topic, lots of nuances in immigration law. So if you are a criminal attorney on this and you have questions, please reach out again before your client does anything. Dominica, there's a question on whether they can get a copy of the presentation.
Yes, I had sent it originally, but I will definitely provide it in the follow-up email that you'll need, that you'll see. Everyone will see the materials as well as the survey needed in order to get credit for attending today's session. As Stacy mentioned, stay tuned for upcoming programs, including this Monday on habeas. There's another question that came in. Is there a written list of Ohio offenses and the immigration consequences?
I'm not aware of one specific to Ohio. There is a chart that generally talks about various crimes and the related immigration consequences, and I sent the link to that to Dominica, so I'm sure she can send out I think there were 2 different links for various materials that I thought could be helpful that can go out with those slides.
Awesome. Yes, definitely we'll share. Well, thank you, Ashley, Sarah, Jessica, and Stacy for your time this afternoon. I know some of you are streaming in from outside of Ohio, so I appreciate you taking the time during your travels to present on this important topic. Everyone, let us know what you thought in the survey, and we hope to catch you at another CMBA program or event. With that, we can go ahead and conclude. Everyone have a great afternoon and a better weekend.
Thank you.
Yeah.
Thank
Bye,
you
everyone.
all. Have a great
Thank
day.
you.
Bye.